And because I thought that, that's why I'm saying this is so hard to prove. It's so hard to predict this and view even negligent behavior as leading to the death of 4 children. There's something in the law called a intervening action. So if you're, chasing someone down the street and they trip and fall and break their leg, you chasing them down the street, it's pretty reasonably foreseeable they might hurt themselves, right? But if you're chasing them down the street and a tree falls on them, I don't know if you can say that that's reasonably foreseeable that the tree was going to fall on them just because you were chasing them. There's an intervening cause, the tree. The intervening cause here is Ethan Crumbley being, doing something monstrous that is hard to foresee no matter how bad of a parent you may have been. So that was a long way of stating the big problem that I see, or difficulty, I should say, not problem, because I think it's just prosecution. I don't think there's anything unethical about the charges. But I think the uphill battle for prosecutors is not that they acted negligently. They absolutely acted negligently. I don't see one reasonable juror concluding that these parents weren't negligent. The question is, did those negligent acts, whatever they were, however numerous, can you say that those caused the death of Tate, Madison, Hannah, and Justin? Can you say that? And I don't know what a jury will do with that.
Now, let me ask you a question on nuance, because I honestly don't know the answer. If you believe as the juror that their gross negligence clearly allowed it to happen, allowed is a little different from cause.
Correct.
Is allowed satisfy the statute?
That's the hard part. When the jury is instructed, they're going to be told that causation means that the necessary thing to happen, I'm using more colloquial terms, but what had to happen, what was reasonably foreseeable and necessary consequence of that action was the murder of 4 children.
Now, I
can't necessarily say that not locking up a gun and not taking the kid home from school necessarily leads to the consequence of 4 children being murdered. I don't know if I can get there. I'm not saying I couldn't if I was a juror. I would certainly listen to the evidence, but I want people to at least think about it. Maybe you're thinking, Wade, you're out to lunch. I would convict in a heartbeat, and that's why we have a jury system. But as I'm analyzing it, that's what I see as the most problematic element, or the biggest uphill battle for prosecutors, is proving that all the terrible things the Crumbleys did that we keep talking about, whether they were terrible or not, did those cause death.
Yeah, and all the terrible things that we understand and to have done, like you said, only get you halfway home.
Exactly.
What we know and what we're mad about, we're only halfway there.
Rightfully so.
And you don't get half convicted.
But think about that. That's where all the anger is directed, right? And actually, Jennifer Crumbley and James Crumbley's lawyers, in their motion to reduce bond, cited the gross negligence instruction. Again, I don't understand it. I don't think this is a debate about being grossly negligent. If those facts can be proven, prosecutor has to prove them. Maybe there's something we don't know.
Discovery looks pretty compelling.
Well, we don't know yet, Justin, if that meeting
you can couch it all you want. The discovery that's out there is pretty compelling.
No, what I'm saying is we don't know how that meeting happened at the school. Maybe it was, something different was said. Maybe they never were shown the picture. I mean, we got to give the benefit of the doubt to that evidence actually being true. I'm only operating on believing this evidence to be true so that we can have a discussion about it. But of course, I mean, if maybe I'm being too critical of the lawyers because maybe they know something I don't. Maybe that meeting didn't take place the way they said it did. Maybe there was an off-the-cuff comment outside the office about this, and they said, oh, okay, I'll come back and get him in a few hours. How do we know? I mean, maybe there is another witness that says something different. So I should qualify that as I'm being critical on other lawyers. It's just tough to do because I don't know all the facts. But I cannot, if true or if difficult to prove, disprove based on what you know about the witnesses. To me, it seems this case is a causation case. Was it foreseeable? Was it a necessary consequence?
If it weren't for the alleged meeting with the note, with the gun, with the blood drawn on the school floor, I'm with you. The ghost shit,
right. I'm
with you the whole way.
But if you start chipping away at that, then you do start questioning whether it was gross negligence. What if there's a witness to that meeting? I'm making this up completely.
Yeah.
There's a third-party witness that says, I don't remember them ever mentioning the note. Well, that changes a lot, what the parents knew and that. So there's things that you can do on cross-examination and in your own investigation that may chip away at some of these things. So we have to reserve the possibility of that.